All right, we're back to libel. We're going to talk about other defenses in libel cases, chiefly qualified privilege. There is an absolute privilege that attaches to members of the executive branch, legislative branch, and judicial branches of government. When people in those branches are doing their jobs, they have complete immunity from libel suits for the words they speak. For example, when the judge convenes court, everything that's said is privileged. Once the city council starts its meeting, everything it's said is privileged. And if a lawmaker says something on the floor of the legislative chamber while the body is session, that's privileged. In fact, in history we have a lot of examples where people speaking on the floor of a legislative body has taken advantage of that to say the meanest, nastiest things about other folks, and they get away with it. But the privilege does not exist during a recess or when the court is adjourned for the day, when the council adjourns, or when the lawmaker is outside of the Capitol and giving a speech. We need to know about privilege because we get a qualified privilege. When we report the words spoken by officials in the performance of their official duties, we are protected from libel suits. Now, it's qualified, and in order to qualify, the reporting must be fair and accurate. In Lorain versus Republican Company, a newspaper published the identity of the wrong person from an arrest report. The newspaper was sued for libel. It defended on the grounds that it had a qualified privilege. It was reporting something from the executive branch, which includes the cops. And the courts there said, well, it wasn't accurate. You got the wrong address. You identified the wrong person. You don't get the privilege. You also have to be careful about adding anything to the privileged communication. If you add opinion, if you add extraneous material, you will lose the privilege. So in Purcell versus Westinghouse Broadcasting, you had a reporter doing a story based upon a grand jury report. The reporter added to the grand jury report comments from people who claimed they were victims of unfair dealing by particular businesses. If the reporter had simply reported the grand jury report, he would have been in good shape. But by adding the commentary of people who were involved in the controversy, he lost the qualified privilege. Now, in the judicial branch, who gets the protection? You get the judge, lawyers, witnesses. Grand jury reports are privileged, and the pleadings. Here's the tricky thing. Sometimes the pleadings are not privileged, at least until they've been filed with the court and a judge has acted on them. This is known as the Campbell rule. The executive branch, formal hearings by administrative bodies get the privilege, and it depends on particular states. Some states say that whatever the police tell you is privileged. Other states say that it has to be a ranking police officer. So once you graduate and wherever you go, check with your boss to see how far down the executive privilege goes. And the legislative branch has the privilege for legislative procedures, even down to town councils. And when a legislative branch has a committee or a subcommittee that is engaged in business, it gets the privilege, but it must be a legitimate committee or subcommittee. Oftentimes we will have a politician who will show up in advance of an election and convene a special inquiry into matters that affect his or her constituents. Unless that lawmaker is conducting this inquiry with a quorum from the committee or subcommittee, it's not a legitimate legislative act, and it's not covered by the privilege. Second, let's take a look at truth as a defense. Truth really isn't a defense. The plaintiff must prove falsity, and we know that from Philadelphia newspapers versus Hepps. But if the plaintiff appears to have established the falsity of the published statement, then we come back and try to prove that it is correct. Now, substantial truth is as good as truth. Minor inaccuracies will not eliminate the truth defense, but only minor inaccuracies, and the truth must be apparent from the publication. As we see in Memphis Press Scimitar versus Nichols, the newspaper published a story that Mrs. Newton has shot Mrs. Nichols after finding Mr. Newton in Mrs. Nichols' home. That was the story. and it conveys the impression that Mrs. Nichols and Mr. Newton were carrying on an affair. That wasn't the case. Mr. Nichols was home, as well as two other people, so it was less of an affair and more of a bridge party. Because the press scimitar left out that important clarifying information, its story was seen to be untrue, even though on its most basic, Mrs. Newton did shoot Mrs. Nichols after finding Mr. Newton in Mrs. Nichols' home. So you have to be careful about that. Now, if you're trying to use truth as a defense, if you've left out part of the story, you lose that defense. In Torres versus Playboy Enterprises, a story included information that the plaintiff had been convicted of a felony, but the story left out the fact that the felony conviction had been overturned. Now, that little detail rendered the story untruthful, and the truth defense did not come into play. Know this, that if you have confidential sources or anonymous sources, some courts will not allow you to plead truth if you don't provide the identity of your confidential sources to the court and the other side. The courts want the plaintiff to be able to test your sources to ensure that what they said was true. Let's move on to opinion and fair comment. Opinions are not statements of fact. Opinion is constitutionally protected, and fact doesn't receive the opinion defense. So you can't simply stick "in my opinion" in front of a libelous statement and expect to get the opinion defense. If your statement appears to have facts that are objectively provable, then it is not simply an opinion. Rhetorical hyperbole falls under the category of opinion. Rhetorical hyperbole is an outrageous exaggeration. When people make jokes, even if they make jokes with identifiable targets, the jokes are considered to be rhetorical hyperbole and therefore are not actionable. But you have to be careful. You may wind up with statements that are a mixture of opinion and facts. Milkovich versus Lorain Journal. We have a near riot that breaks out at a wrestling match involving Maple Heights High School. The school is eliminated from postseason play. The coach and wrestling boosters go to a hearing for the group that oversees interscholastic competition. The coach tells a story that it wasn't the fault of his players or his school. The interscholastic competition governing body doesn't take him at his word. Boosters file lawsuit in a local court. The coach testifies that it wasn't the fault of his players or himself or the school. The judge dissolves the ban on postseason play for the high school. A newspaper sports columnist, Theodore Diadian, who has a regular column under the bug TD Says, writes a column in which he says that Coach Milkovich, he was the coach at Maple Heights, did a disservice, that he taught his students a terrible lesson. And the lesson was, if you get into trouble, tell the big lie. And Diadian, who was present at the wrestling meet, who was present at the proceeding in front of the governing body for interscholastic competition, but who was not present in the court hearing, wrote that Coach Milkovich lied during the proceedings. Milkovich sued. Well, if you think about it, if you tell a lie in court, you are committing the crime of perjury. So even though Theodore Diadian is writing an opinion column, he made an assertion of fact that Milkovich had in fact perjured himself. Milkovich sued the Lorain Journal, defended on the grounds of opinion and fair comment. The Supreme Court ruled that a mixture of opinion and factual statements left the newspaper on the hook. In other words, the newspaper could not rely upon the opinion defense for its factual statements regarding perjury on the part of the coach. So keep that in mind. We'll be moving on to privacy. So be ready for that.